We looked at the doctrine of parliamentary sovereignty in the previous section. In this section, we will look at the doctrine of the rule of law. Both of these principles contradict each other in the sense that if the parliament is sovereign, it can undermine the rule of law by making any legislation. This legislation can be contrary to the fundamental rights or the civil liberties of the people. On the other hand, if we take a strict interpretation of the rule of law, then the parliament cannot be seen as sovereign because the law itself restricts parliamentary sovereignty. Like parliamentary supremacy, the rule of law is also a complicated concept, which is open to interpretation by the judges and may have different meaning in different countries based on the constitutional arrangement of that country. In a US context, the rule of law is built into the constitutional arrangement. However, this is not true in a British context. You can argue that the British constitutional arrangement is moving towards a clear separation of power with acts like Constitutional Reform Act 2005. We will come back to this argument when we look at the doctrine of separation of power. To get a clearer idea of what we might mean when we use the phrase rule of law, we will look at the following: different definitions of the rule of law, different approaches to its understanding, and how the judges, parliament, and the government uphold the rule of law. If we go back to the examples of a traditional monarch, we will see that traditional idea of a king is that he is above the law and can make or destroy law with his whim. The royal family, the king's council, and all other officials working for the king may be granted protection from one or more laws, which basically means that they are above the law. Do you think that such a simple and traditional form of government can work in today's age where the government faces complex challenges every day? Or perhaps more straightforward question would be, would you like to live in such a country where the king and his family has protection from the law and the absolute power to make arbitrary laws? The answer is most likely no, because you would want to exercise your freedom and have protection for your rights against the king and all of the king's men. For the protection of your rights against the whim of the king, we need to look at the powers of the traditional king in a different way. According to the Scottish theologist Rutherford, the prince remains, even being a prince, a social creature, a man as well as a king, one who must buy, sell, promise, and contract. Therefore, he is not above the law, but under the rule of law. If we want to go further back in time, we find Aristotle, who states in his work, The Politics, that law should govern a country instead of men. Now, let's look at the opposite spectrum of the picture. What if there were no laws and everyone had absolute freedom to do what they would like to do? Do you think it's a good idea to give everyone the freedom to do what they want? What would be a logical consequence of such a constitutional arrangement? Would you imagine that this situation will lead to chaos and anarchy? People will have to make their tribes and groups to protect and survive in a lawless world. See the blog post in section 3 named Anarchy and Rule of Law. Watch the video and leave us your comment. In a British context, when we look at the constitutional arrangement, the starting point for the discussion of the rule of law is dicey. The reason I say the British context is the unique separation of power arrangement we have compared to the US. The American Bar Council does not include the views of Professor Dicey in their discussion of the rule of law. Dicey's rule of law will not align with the clear separation of powers between different branches in the constitutional arrangement like the legislature, judicial, and the executive branch. However, the American Bar Council also recognizes that the rule of law may not depend on the separation of power in a parliamentary system. So coming back to Dicey in the parliamentary system of Britain, let's look at why we choose his view as the starting point of the discussion. There are two reasons to study Dicey's views on the subject before another view is considered. First, his view represents the historical development of the doctrine in Britain over time. Second, it provides a simpler view of the doctrine that will help us build on our concept of the doctrine as we discuss it further. So, Dicey divides the idea of the rule of law into three limbs, giving us the opportunity to analyze the idea further. The first limb of his theory is that no one should be punished by the executive before they are given a chance to go through the common law courts and procedures. The second limb is that no man is above the law. This includes the governmental officials who ordinarily hold more power than a regular citizen. Third, the courts will determine the rights of the citizens. This means that there are no defined sources of law. Let's look at the first limb of the rule of law again and see if we can find a flaw in that description. So the first limb states that no man should be punished without the due process. Do you think that happens in reality? Can you think of a situation in recent times when a minister or a governmental official took a step that punished someone without the due process? Sir Jennings criticized Dicey and stated that in practice, officials have powers and are not always scrutinized by the courts. This statement was especially true in the times Dicey introduced his conception of the rule of law. What Sir Jennings here is doing is known as the counterexample technique in logic. How this method works is that you give an example that falsifies a statement, making it less persuasive. Okay, what about the second limb, where Dicey states that no official or citizen is above the law? Do you think there is a counterexample that you can provide? Is there a group of people you can identify that have more rights or are immune from the law of the land? Sir Jennings points out that the rights of the citizens and the officials are not the same in any way, and there are officials such as diplomats that are immune to the laws because of their unusual public role. Let's move on to the third limb, where Dicey states that courts determine the rights of the citizens. Can you provide an argument that will rebut this statement? Let me give you a hint. Think of the sources of law. Can you think of a source of a law that is not driven from ordinary laws? Are there any constitutional statutes or historical documents that may indicate that they are a source of rights of citizens and the courts are bound to respect and follow these historical documents? If you are thinking about the Magna Carta, Bill of Rights, the Act of Union, and the Human Rights Act, you are right. This limb can be accepted as it is if we accept Dicey's traditional view on the sovereignty of the Parliament. Otherwise, it can be argued against. Even though Dicey's definition of the rule of law is not perfect, it still provides a starting point in the evolution of the doctrine. This leads us to the modern definition of the rule of law by Lord Bingham. The progression in the definition of rule of law can be compared with the Magna Carta. That was originally set out to safeguard the rights of the feudal lords, but later gave way to the Bill of Rights and in the modern Britain to the Human Rights Act.